Obergefell V. Hodges was a monumental case regarding the rights to same-sex marriage. This case began when James Obergefell and John Arthur James filed a lawsuit in the state of Ohio challenging its refusal to recognize same-sex marriage on death certificates. James Obergefell and John Arthur James were legally married in 2013 in the state of Maryland. John Arthur James, suffering from a terminal illness, passed away shortly after litigation began. The case was initiated on July 19, 2013 in the United States District Court for the Southern District of Ohio. On July 22, 2013, the judge presiding over the case, Judge Timothy S. Black, granted Obergefell a temporary restraining order, forcing the state of Ohio to recognize the marriage. On September 26 of that year, David Michener and Robert Grun were added as plaintiffs to the case in an amended complaint. In this complaint, the plaintiffs stated that Ohio's practice of denying recognition of marriages lawfully performed in other states on death certificates is unconstitutional and requested an injunction to stop this practice. On December 23, 2013, Judge Black held that Ohio's decision violated the couple's right to equality and due process. This decision was later appealed to the Sixth Circuit Court of Appeals by Womislow on January 16, 2014, and on April 10 of 2014 he filed his appellant brief. Womislow was then replaced by Richard Hodges when he became director of the Ohio Department of Health in August of 2014, who was then replaced by Mr. Himes. On April 24th, Obergefell filed his brief, and on May 12th, Himes filed his reply brief. On November 6th of 2014, Judge Black's decision was reversed. On November 14th of 2014, Obergefell filed a petition for a writ of certiorari with the U.S. Supreme Court, and on January 16th, 2014, the U.S. Supreme Court issued an order granting certiorari and agreeing to hear the case. The case was heard on April 28th of 2015. The Supreme Court asked both parties to prepare a brief on the amendment in question, which was whether the 14th Amendment requires a state to license a marriage between two people of the same sex, and whether the 14th Amendment requires a state to recognize a marriage between two people of the same sex when their marriage is lawfully licensed and performed out of the state, the latter of which was discussed within the court. The 14th Amendment states, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law." The plaintiffs in each case argued that the state statutes violated the Equal Protection Clause and Due Process Clause of the 14th Amendment, and one group of plaintiffs also brought claims under the Civil Rights Act.
The petitioners claimed that the state laws violate the Due Process Clause of the 14th Amendment by denying their right to marry or have their marriages lawfully performed in another state. They also declared that the state laws violated not only the Due Process Clause but also the Equal Protection Clause as well. The right to marry, including same-sex couples, is fundamental under the Constitution for 4 reasons. 1. Individual autonomy dictates a personal choice on who to marry. 2. People have a right to enjoy intimate association. 3. It protects families and children, since having unmarried parents may cause children to suffer. 4. Marriage is a keystone to the nation's social order. Any person, no matter their gender, should be given equal access to the constitutional right to marriage, a statement in which the court has long declared as a fundamental right. Legalizing same-sex marriages will protect gay people from the harsh discrimination against them, such as being denied employment or housing, since it will establish a new constitutional norm. In addition, they claim that same-sex marriages will not undermine straight marriages, in which the states are mainly concerned. The petitioners' contentions underlies in the respect and need for the marriage privileges and responsibilities, which is the only real path to a profound commitment. In conclusion, the petitioners claim that the right to marry is a fundamental human dignity on a couple, so denying that right is harmful to them and may actually disrupt familiar bonds with children. Excluding gay and lesbian couples from marriage demeans the dignity of these couples and also their children's stabilizing structure that marriage affords. In response, the states argued that the 5th and 14th Amendments only protected the people from the physical restraint and government invasion, and that they do not grant the people the right to government entitlement. Furthermore, the states protested that gay marriage would fundamentally change the institution of marriage, which has been in place for thousands of years, which may cause unintended consequences similar to how no-fault divorce laws may have changed the nature of marriage and increased the number of single parenthood. They also added that a state has no constitutional obligation to license same-sex marriages or to recognize same-sex marriages performed out of the state. Deciding marriage law is a state's right issue, and for the court to take away that right is an infringement on liberty. The states claim that the court should not go beyond their given power to decide if states have to recognize or license the marriage. In addition, they affirmed that prohibiting gay marriage is based on rational arguments and are not discrimination towards gays and lesbians, also quoting the fact that the laws must be rationally related to a legitimate governmental interest, but does not necessarily mean that the rationale must be correct.
The outcome of the case was ruled in favor of same-sex marriage. The vote was 5 to 4. According to the opinion written by Justice Anthony Kennedy, he claims that the right to same-sex marriage is granted by the Constitution and that same-sex couples respect marriage and ask for equal dignity in the eye of the law. No union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. In forming a marital union, two people becoming something greater than once they were, as some of the petitioners in these cases demonstrate. Marriage embodies a love that may endure even past death. It would misunderstand these men and women to say they disrespect the idea of marriage. Their plea is that they do respect it so deeply that they seek to find its fulfillment for themselves. Their hope is not to be condemned to live in loneliness, excluded from one of civilization's oldest institutions. They ask for equal dignity in the eyes of the law. The Constitution grants them that right. He also acknowledges that people who strongly believe that marriage should be only between a man and a woman will continue to oppose same-sex marriage. That debate should continue, he writes, but the marriages must be allowed. Justice Kennedy points out that the founders gave the country a Bill of Rights, with no rulebook or formula for deciding what is on or off the list. It evolves, he explains, as it did when the Supreme Court held that the right to marry is protected by the Constitution in Loving v. Virginia. On the other hand, Justice John Roberts believes that same-sex marriage is an issue that should be left for the state to decide rather than the Supreme Court. But this court is not a legislature. Whether same-sex marriage is a good idea should be of no concern to us. Under the Constitution, judges have power to say what the law is, not what it should be. The people who ratified the Constitution authorized courts to exercise neither force nor will, but merely judgment. Justice Scalia agrees with Roberts by stating, "The states are free to adopt whatever laws they like, even those that offend the esteemed justice's reasoned judgment." The impact of the court's ruling is that same-sex couples should now be allowed to marry in every state and to have their out-of-state marriages recognized in other states. The ruling of Obergefell challenges to the laws of 4 states: Kentucky, Michigan, Ohio, and Tennessee. Another issue that will surface is religious liberty. Religious clergy have the First Amendment freedom not to perform a religious wedding ceremony contrary to their beliefs. The battle will likely be over whether a public official with religious objections to same-sex marriage may refuse to issue marriage license or solemnize marriages, and whether business owners with such objections may refuse to provide wedding-related goods and services.
Obergefell v. Hodges may not have overturned any previous court decisions, but its impact was immediate and long-term, allowing same-sex couples to finally get married.